Now here, before proceeding with the subsequent provision, we need to look at one thing here, which again is what exactly does the interim moratorium provision say, right? It says when an application is filed under 94 and 95, interim moratorium shall commence, which will extend to any legal action or proceeding pending in respect of any debt, right? So now here you can see that the purport behind this is quite simple, that when an individual is undergoing a resolution process, it is essential to ensure that whatever assets are there, which will of course be much more limited in comparison to a corporate entity, these assets need to be protected, right? Now this seems to be the intent behind this provision. However, when you say any debt, what is the connotation there? This was the question before the Supreme Court in this very recent judgment in Saranga Anil Kumar Agarwal versus Bhavesh Dheerajlal Sheth. Now the backdrop behind this essentially was such that it rose, the question that rose was whether or not the debt, any debt as defined under, as mentioned under section 96 would extend in respect of penalties levied under the Consumer Protection Act of 1986. Therefore, basically to say whether or not when the interim moratorium under section 96 is still in force, can the penalty under the Consumer Protection Act 1986 be enforced or be levied against the guarantor, right? That's the question that the Supreme Court is faced. The answer can be seen here in paragraph 30. Right. Yeah. A distinction must be drawn between the moratorium period applicable to a corporate debtor under section 14 of the IBC and the interim moratorium applicable to individuals and PGs under section 96 of the IBC. The former, which is section 14, is much broader in scope and states all proceedings against the CD, including execution and enforcement actions. However, section 96 of the IBC is more limited in its scope, staying only legal actions or proceedings in respect of any debt, right? So here the Supreme Court has attempted to clarify and classify the scope of moratorium under section 14 and section 96, wherein it is saying that the one under section 96 is much more limited in nature. Now what is the reason behind that? The Supreme Court says, unlike corporate insolvency proceedings where the goal is a comprehensive resolution of the company's liabilities, individual insolvency proceedings are designed primarily for restructuring personal debts and providing relief to the debtor, right? So here the court has classified and divided and differentiated between the objective of the resolution and the difference in the nature of the resolution itself when it comes to a corporate entity and when it comes to a personal guarantor or an individual, right? Wherein the court says in the former case, it's a much more comprehensive resolution. There are a lot more stakeholders involved. There are a lot more aspects to be considered. There are just too many moving parts which have to be taken into account, etc. Whereas in case of an individual insolvency, it is just to ensure that whatever personal debts are there are restructured and the relief is provided to the debtor. Looking at it from a slightly different angle, it is basically to say you restructure the debt of the personal guarantor in a manner that his liability under the guarantee contract is extinguished or is mitigated or is covered or fulfilled, etc. Now coming back to the observations of the Honorable Court, the legislative intent behind limiting the scope of interim moratorium under section 96 must be respected, and a blanket stay on all regulatory penalties would result in defeating the objectives of consumer protection laws. Now although this observation is made in the particular context of the Consumer Protection Act, what needs to be understood here is quite simple, that the reason why the legislature has provided this interim moratorium is to ensure some sort of relief to the individual who is undergoing resolution process, to ensure that not all of his liabilities are piling up against him to his detriment and he is paralyzed and immobilized, right? There is some sort of breathing space that is required. Now this is the sole reason why interim moratorium has been provided. However, as we have seen in the past with other bankruptcy legislations as well, what might end up happening is that these individuals will end up misusing these provisions and shield under the moratorium to avoid all their other liabilities, right? So in this case, it is under the Consumer Protection Act, the penalty which is payable, right? In other cases, it might be more serious penalties or more severe penalties which might be payable, which are now stayed solely because of the ground of interim moratorium, which is not permissible and which, as the Honorable Supreme Court has held, is not in accordance with the legislative intent behind the interim moratorium under section 96. Now further look at para 31. It says moratorium under section 96 of the IBC, which is interim moratorium, is intended to provide temporary relief to debtors by preventing certain proceedings against them during the resolution process. However, this protection is not absolute and does not extend to all categories of debts. The legislative intent behind the moratorium is to ensure that the debtors' assets are preserved for an efficient resolution process and to prevent creditors from taking unilateral actions that may frustrate the objectives of insolvency proceedings. And it further goes on to say, however, the statutory scheme of the IBC makes it clear that the protection under the moratorium does not cover all forms of liabilities, particularly those classified as excluded debts under section 79, subsection 15 of the IBC. Therefore, the Supreme Court has held, forget the provision, look at the statutory scheme of the IBC itself, then it makes it very clear that when a debt is said to have been excluded, then there is no reason for you to extend the scope of moratorium to such debts, right? So that is a very logical corollary of the provision and the scheme of the code itself. Moving forward, the Supreme Court is held, respondents have rightly contended that section 94(3) explicitly limits the scope of the moratorium by carving out exceptions for certain categories of debts. 79(15) defines exclusive debts to include liabilities, etc. This classification is based on the nature of such obligations, which are either statutory, penal or personal in nature, and therefore do not form part of the insolvency estate that can be discharged under the resolution process. So the reasoning and the logic of the Supreme Court basically is that you cannot read the interim moratorium provisions in such a manner that debtors are allowed to have a shield over all kind of liabilities or kind of debts, especially when there is a statutory classification of a debt and an excluded debt, right? And when there is a definition of debt under the statute, it does not make sense to depart from that definition or from the classification of excluded debt and then forcibly extend interim moratorium. So this is the objective and this is the reasoning as analyzed by the Honorable Supreme Court. Now proceeding with the resolution process. Section 97 deals with appointment of resolution professional. So till here we have seen how interim moratorium will become applicable, when exactly it happens, who can make an application, which is either the creditor or the debtor, and the scope and extent of interim moratorium. Now with respect to appointment of resolution professional, subsection 1 says, if application under 94 or 95 is filed through the RP, so there, if you recollect, there is an option for it being filed either by the debtor or the creditor or through the resolution professional. So here it says either personally or through a resolution professional. With respect to creditor, it says either by himself, jointly with other creditors, or through the resolution professional. So here there is an option of engaging the resolution professional prior and then making an application through the RP. Section 97 says, if application under 94 or 95 is filed through an RP, the adjudicating authority shall direct the board within 7 days of the date of application to confirm that there are no disciplinary proceedings, which is what we have seen even in CIRP and PPIRP. Board shall within 7 days either confirm the appointment or reject the appointment of the RP and nominate other RP for the insolvency resolution process. Now here, what happens when the application is filed personally, either by the debtor or the creditor, is what is envisaged under subsection 3, which says, when an application under section 94 or 95 is filed by the debtor or the creditor himself, as the case may be, and not through the RP, right, the adjudicating authority shall direct the board, which is IBBI, within 7 days of the filing of such application to nominate an RP for the insolvency resolution process. So here, the onus shifts upon the Insolvency and Bankruptcy Board of India, where the application has been made personally by a debtor or a creditor. IBBI has to make the nomination of that RP within 10 days. Then the adjudicating authority will pass an order specifically to appoint the RP who has been nominated under subsection 4 or who has been recommended under subsection 2 when the RP has already been, when the application itself was already filed through the RP. A resolution professional appointed by the AA shall be provided with a copy of the application for the insolvency resolution process for, of course, natural and obvious reasons. Coming to section 98, it deals with replacement of the RP. Now here, who are the involved persons? whether debtor or the creditor is of the opinion that the RP appointed under section 97 is required to be replaced, he may apply to the adjudicating authority for the replacement of such RP, right? So it's either the debtor or the creditor. The replacement shall be made within 7 days. The order shall be passed by the adjudicating authority within 7 days, wherein the reference will be made to the IBBI, right? The first 7 days, the reference will be made to the IBBI seeking replacement of the RP, right? The IBBI, within 10 days of the receipt of a reference from the adjudicating authority, will recommend the name of an RP, and it's crucial to ensure that there are no disciplinary proceedings which are pending against that RP. So here, the onus is again on the IBBI to ensure that whatever name it is recommending is of such a person against whom no disciplinary proceedings are pending. Now here there is another alternate route at which the RP can be replaced, is where at the meeting of the creditors, if the creditors decide that the RP will have to be replaced, and then an application can be made before the adjudicating authority to replace the RP with the new RP for the implementation of the repayment plan. And then subsection 5 says that the adjudicating authority submits an application under subsection 104, it shall direct the board to confirm there are no disciplinary proceedings. So this is something we have seen previously also. Within 10 days, the board will send a communication confirming his appointment or rejecting the appointment of the RP and recommending a new RP. Basis the communication received from IBBI, order will be passed by the NCLT appointing the new RP. Now, before the old RP demits his office, he will have to share all relevant information with the new RP, cooperate with the new RP in whatever manner as may be required. Now coming to section 99, which is a very crucial section in the scheme of the insolvency resolution process against for individuals, including personal guarantors. Section 99 says submission of report by the RP. Subsection 1 says the RP shall examine the application referred to in section 94 or section 95 as the case may be within 10 days of his appointment and submit a report to the adjudicating authority recommending for approval or rejection of the application. So here the application itself is subject to scrutiny by the RP, right? It is not the case where the application has already been filed, has been admitted, and then RP is appointed and then the subsequent process. Here it's slightly different, inasmuch the application itself will be scrutinized by the RP, who will then file a report with the adjudicating authority recommending either the approval or the rejection of the application itself. Now subsection 2 says whether an application has been filed under section 95, the resolution professional may require the debtor to prove repayment of the debt claimed as unpaid by the creditor by furnishing evidence of electronic transfer of the unpaid amount, evidence of encashment of check issued by debtor, or a signed acknowledgement by the creditor accepting receipt of dues. So here it is an opportunity to the debtor to show that when the creditor has filed the application, the debtor gets an opportunity to show that the payment has already been done. That he can do either through evidence of electronic transfer or evidence of any check which has been encashed or any signed acknowledgement which has been received from the creditor. Subsection 3 then says, where the debt for which an application has been filed by a creditor is registered with the information utility, the debtor shall not be entitled to dispute the validity of such debt. So here again, it's quite in line with the objectives of the code. The reason behind why you have an elaborate procedure and elaborate processes and rules and regulations governing the information utilities is to ensure that whatever database is with this IU is credible and reliable, right? So here, let's say the information utility clearly records that there is a debt which the debtor owes to the creditor which has not been repaid. In that case also, if you are allowing the debtor to come and raise objections or show proof to the contrary as to how the debt has been repaid, it is basically distrusting the veracity of, rather undermining the veracity of the information with the information utility. So this clarification, although very minor in nature, is crucial to preserving the overall objective and schematics of the code. Subsection 4 says, for the purpose of examining an application, the RP may seek such further information or explanation in connection with the application as may be required from the debtor or the creditor, or any person who, in the opinion of the RP, may provide such information. So here again, this is similar to the duties or the powers of the RP that we have seen so far, which is he has the power to seek relevant information from relevant stakeholders. Now subsection 5 says the person from whom information sought shall furnish such information within 7 days. So here again the time bound aspect now comes into play. So if you look at the overall provisions of the IBC as well, across the chapters, in each of the provision more or less you will be able to see one of the objective of the IBC being reflected, right? So as we have seen previously, the preservation of the sanctity, not the sanctity, rather the veracity or the credibility of the information that is with the information utility, that is one aspect. Now coming to here, the time bound aspect, and so far whatever other provisions we've seen with respect to, let's say, interim moratorium or even the other provisions which we've seen thus far, they would reflect things such as value maximization or ensuring that the interest of both the creditors as well as the debtors, be it the corporate or personal guarantors, all these are protected. So this is one very unique aspect of the IBC that we can also see being reflected under here. Anyways, back to the provision. Subsection 6 says the RP shall examine the application and ascertain the following. 1. Application satisfies requirements under 94 or 95, which is very straightforward. And 2. The applicant has provided information and given explanation sought by the RP under subsection 4, which is basically whatever information has been sought by the RP, the answer has been provided by the debtor. Coming to subsection 7, it says after examination of the application under subsection 6, the RP, that he here is the RP, may recommend acceptance or rejection. When the RP finds that the debtor is eligible for a fresh start under chapter 2, the RP shall submitting a report recommending the application by debtor under section 94 be treated as an application under section 81. Now because it will be too much of a digress if we look into fresh start, we shall not be going into that, but just keep this in mind that the fresh start process has its own set of advantages in comparison to a drawn out process under IRP, right? So here the RP is vested with the power to recommend, right? Only to recommend that a fresh start chapter be, that the fresh start application be made, or rather the application which is already made under section 94 be considered as an application under section 81. Subsection 9 says the RP shall record the reasons for recommending the acceptance or rejection of the application. Naturally, right, it has to be a well reasoned report. Any report that you are making, you cannot blankly state why that this needs to be approved or this does not need to be approved, needs to be rejected. You need to provide the solid reasons behind the same. Subsection 10 says the RP shall give a copy of the report to the debtor or the creditor as the case may be, which is a matter of procedure that is quite applicable everywhere. Coming to section 100, it says admission or rejection of application. So this is a very crucial provision because this is where technically the insolvency resolution process kickstarts. So if you remember in PPIRP, there were 3 stages, right? There is a informal stage, application stage, and then there is a formal stage. Here it is somewhat similar in as much the first stage is pre-application stage and now it is post-application stage. This is the intervening area. Section 100 is the intervening area which deals with the admission of the application itself. What does it say? Subsection 1 says the adjudicating authority shall, within 14 days from the date of submission of the report under section 99, pass an order either admitting or rejecting the application under 94 or 95, right? So if a debtor or creditor makes an application within 14 days of submission of the report under section 99 on such application, right, where the RP's report on admission or denial, within 14 days of that report being filed, an order either admitting or rejecting this application which has been filed has to be passed by the adjudicating authority. Subsection 2 says, where the adjudicating authority admits an application under subsection 1, it may on the request of the RP issue instructions for the purpose of conducting negotiations between the debtors and creditors and for arriving at a repayment plan. So here again, if you look at it, there are 2 aspects to this. Now, a negotiation between a creditor and a debtor might not be always feasible in all cases, especially when an application has been filed by the creditor, right? When a creditor is looking to file an application under 95, it means a thought process has gone as to why a negotiation won't work and why this step of initiating IBC proceedings is a requirement. So it is not always feasible for creditors and debtors to sit and negotiate. Therefore here subsection 2 of section 100 puts 2 barriers which have to be cleared. What are they? First, it is to be based as the request of the RP, which is the negotiation between creditors or debtors has to be based on the request of the RP. And second, if you read the provision itself, it's very clear that this is left to the discretion of the adjudicating authority. Merely because the RP has requested, it does not mean that as a matter of right, the creditors and debtors will get permission to negotiate. It is still on the discretion of the RP, of the adjudicating authority. And here it's again very clear that the scope of this provision, or rather the scope of the adjudicating authority's power under this provision, is only to issue instructions for the purpose of conducting negotiations between the debtors and creditors, right? So the ultimate negotiation will take place, but here the adjudicating authority will kind of have a supervisory role in providing instructions and ensuring that they are being complied, for which again we have the RP. Subsection 3 then goes on to say, the adjudicating authority shall provide a copy of the order passed under subsection 1 along with the report of the RP and the application under 94 and 95 to the creditors within 7 days from the date of the order, right? So here, whenever the NCLT has either admitted or rejected it, within 7 days, that order copy along with these other documents including the RP report as well as the application by the debtor or the creditor, all these documents will have to be provided to the creditors within 7 days from the admission order. Now subsection 4 says, if the application referred to under section 94 and 95 is rejected by the adjudicating authority basis the report of the RP, and the report of the RP states that this application was made with the intention to defraud the creditors defraud the creditors or the resolution professional, right? So when an application is being made under 94 and 95 to defraud either the creditors or the resolution professional, then the order under subsection 1 shall record that the creditor is entitled to file for a bankruptcy order under chapter 4. So that is something we shall be looking into subsequently. Now section 101 says deals with moratorium. So here again section 96, as we have seen, has also seen the judgments of the Honorable Supreme Court. The scope of 96 is quite limited. Now let us distinguish that from section 100, which is the moratorium that comes into place after the application has been admitted. When the application is admitted under section 100, a moratorium shall commence in relation to all the debts and shall cease to have effect at the end of the period of 180 days beginning with the date of admission of the application or on the date of the adjudicating authority passes an order on the repayment plan under section 114, whichever is earlier. So here again you see an extra element of time in respect of a section 101 moratorium, which is previously missing. It says subsection 2 is very crucial. It says during the moratorium period, A, any pending legal action or proceeding in respect of any debt shall be deemed to have been stayed. B, the creditors shall not initiate any legal action or legal proceeding in respect of any debt. And C, the debtor shall not transfer, alienate, encumber or dispose any of his assets or his legal rights or beneficial interest therein. So here it's very clear that under 96 it's only with respect to any pending legal action or proceeding, whereas here section 101 covers two more scenarios, which is initiating of fresh proceedings or fresh legal action by creditors as well as alienation of properties by debtors. All of this is now prohibited by virtue of the moratorium. Subsection 3 says where an order admitting application under 96 has been made in relation to a firm, moratorium under subsection 1 shall operate against all the partners. So this again is not very relevant to us. Moving on to subsection 4, the provisions of this section shall not apply to such transactions as may be notified by the central government. This is a replica of what we have seen under section 96 and 14 as well. Now coming to section 102, which is the next logical step in the resolution process, which is public notice and claims. Now the adjudicating authority shall issue a public notice within 7 days of passing of the order under section 100 inviting claims from creditors. So here it's not the RP but the adjudicating authority. So that's a very crucial difference. Notice under subsection 1 shall include the following: A, details of the order admitting the application; B, particulars of the RP with whom the claims have to be registered; and C, the last date for submission of claims. So here again we can see that the notice has to be published in one English and one vernacular newspaper, has to be affixed in the premises of the AA, and C, placed on the website of the adjudicating authority. Now coming to the registering of claims by the creditors, which is a subsequent step. This will be done with the RP as we have seen under 102 itself. How shall it be done? The creditors will register their claims with the RP by sending details of the claims by way of electronic communications or through courier, speed post or registered letters. So there are multiple modes through which the creditors have the right to submit their claims before the RP. So here if there are any personal information or any particulars which are prescribed, under the 2019 rules, those will have to be furnished by the creditor in addition to whatever claims are there under subsection 1. Now comes the duty of the RP, right, which is firstly preparation of the list of creditors. The RP shall prepare a list of creditors on the basis of the following. Firstly, information disclosed in application filed under 9495, and B, claims received by the RP under section 102. So here it is not as if the RP will only look at what are the claims which are being received by the creditors. Of course, that will have to be vetted and verified, sure. However, to ensure that there are no, loopholes, or to ensure there are no loose ends, the RP will also have to look into the information which has been disclosed in the application that has been filed either by the debtor or the creditor under section 94 and 95 respectively. Subsection 2 says, the RP shall prepare the list mentioned in subsection 1 within 30 days from the date of notice. Notice here is a public notice, right? The public notice itself is issued within 7 days from passing of the admission order, and 30 days within the date of the notice, the RP shall prepare the list under subsection 1, which is the list of creditors. Now coming to the repayment plan, which is our equivalent of a resolution plan in case of a CIRP. The personal guarantee equivalent is the repayment plan. Subsection 1 says, the debtor shall prepare in consultation with the RP a repayment plan containing a proposal to the creditors for restructuring of his debts or affairs. So here you can see that similar to PPIRP, where the promoter of an MSME has the right to sit and make a base resolution plan, here it is the debtor who shall be preparing the repayment plan, and that too in consultation with the RP. Right, now this will be put forth before the creditors, that we shall see subsequently. Subsection 2 says, the repayment plan may authorize or require the RP to do the following. A, carry on the debtor's business or trade on his behalf for his name, or realize the assets of the debtor, or administer or dispose of any funds of the debtor. So here again, this is left to the discretion of the debtor to vest the RP with these rights. What are these rights? Carry on the debtor's business, realize his assets, or administer or dispose of any of his funds. So all of these aspects, if the debtor feels he can handle it himself, well and good. However, if, depending on his prudency and depending on the gravity of the situation, if he feels it is better left with the RP, then naturally the provision empowers him to leave it to the resolution professional. Subsection 3 says, the repayment plan shall include the following, namely A, justification of preparation and reasons on the basis of which creditors may agree upon the plan. Right, so it's basically a pitch, right, where you are selling your repayment plan to the creditors. You are selling the idea of why or how your debts will be restructured and why this is the best manner, and that will have to be incorporated. All those reasons and justifications will naturally have to be incorporated in your repayment plan. B, provision for payment of fee to the RP, and C, such other matters has to be specified. Now coming to section 106, which deals with report of the RP on repayment plan. Subsection 1 says, the RP shall submit the repayment plan under section 105 along with his report on such plan to the adjudicating authority within a period of 21 days from the last date of submission of claims under section 102. So here the last email or the last RPID which has been received by the RP with a claim in it by a creditor, that is the cutoff date, that will be the date taken, and within 21 days from that date, the RP will have to submit the repayment plan along with his report. Now what will the report encompass, or what will the report include? Report under subsection 1 shall include that A, repayment plan is in compliance with the provisions of law, repayment plan has a reasonable prospect of being approved and implemented, and there is a necessity of summoning a meeting of creditors if required to consider the repayment plan. Provided that where the RP recommends that a meeting of creditors is not required, reasons for the same have to be provided, right? So here, if let's say a plan has been put forth by the RP along with his report, now the report just merely says no meeting of creditors is required, right? Now the adjudicating authority will have no backdrop, right? It is essential for the adjudicating authority to be kept in loop as to why do the creditors not, or why should a meeting of the creditors not be convened, and why should the creditors not go through this entire plan and discuss. So for this, to avoid that, your proviso clearly and categorically states that where the RP recommends a meeting is not required, reasons have to be provided. In addition to the above, subsection 3 says, the report shall also specify the date on which and the time and place at which the meeting should be held if the RP is of the opinion that a meeting should be summoned. Subsection 4 says, for the purposes of subsection 3, which is the meeting, date on which the meeting shall not be less than 14 days and not more than 28 days from the date of submission of report under subsection 1. And B, the RP shall consider the convenience of creditors in fixing the date and venue of the meeting of the creditors. So here again, this is an additional duty of the RP to ensure two things. First, whether or not a meeting is required. If not, why the reasons have to be furnished in the report. Two, if the RP is saying that a meeting is required, then the onus of arranging, convening and ensuring everything is in place falls upon the RP. Coming to subsection 107, it says summoning of meeting of creditors. RP shall issue a notice at least 14 days before the date fixed for such meeting. RP shall send out the notice of meeting to the list of creditors prepared under 104. Notice shall state the address of the adjudicating authority to which the plan and report of the RP has been submitted and will be accompanied by the following documents: copy of repayment plan, copy of statement of affairs of the debtor, copy of the report of the RP, and forms for proxy voting. So here again you can see that because of the peculiar nature of personal insolvency resolution process, these additional documents become necessary. So again the rules will specify the manner in which the proxy voting and e-voting will be conducted. Section 108 says conduct of meeting of COC. The meeting of COC shall be conducted in accordance with 109, 110 and 111, which we shall see subsequently. In the meeting of the creditors may decide to approve, modify or reject the repayment plan. So because that is the reason the meeting is being convened, right? To consider the repayment plan and to see whether it can be approved as is, whether it requires any modifications, additions, deletions, etc. Subsection 3 says the RP shall ensure that if modifications are suggested, consent of the debtors shall be obtained for each modification. So here you can see that there is a slight departure where from the creditor in control mode of the IBC. So CIRP or PPIRP, we have seen that creditor in control mode being reflected in the manner the provisions are there. However, for personal guarantors or rather individuals, right, the resolution process still bears some semblance of the previous model of debtor in control, right? However, in comparison to the previous legislation such as the Provisional Insolvency Act or the SICA, for example, this IBC code, the process under the IBC code still gives a larger say to the creditors. Although this time through the RP, the creditors still have a lot more, the scope of their right to approach the adjudicating authority to challenge various aspects of the personal guarantee proceedings are a lot wider in comparison to the previous position. Therefore, here, although the departure is there, I do not think it is that significant that it will detriment or that it will be to the detriment of the creditors. Anyways, proceeding with the provision. Subsection 4 says RP may for sufficient cause adjourn the meeting for a period of not more than 7 days at a time. Now the maximum number of times that can be adjourned has not been specified. Now subsection 109, voting rights and meeting of creditors. Subsection 1 says the creditor shall be entitled to vote at every meeting of the creditors in respect of the repayment plan in accordance with the voting share assigned to him. So here there is no classification of financial creditors, operational creditors, or only financial creditors will be sitting in the meeting of the creditors, nothing of that sort. Here creditors are a bunch, right? They are more wholesome in nature and holistic in nature. Subsection 2 says the RP shall determine the voting share to be assigned to each creditor in the manner specified with the board. Subsection 3 says the creditor shall not be entitled to vote in respect for a debt for an unliquidated amount. So here only if you have a specified amount can you be voting, right? You have voting rights. Otherwise, you would not have a voting rights. Subsection 4 says the creditor shall not be entitled to vote if he, A, is not a creditor mentioned in the list, or B, is an associate of the debtor. So here again, that disclosure or rather that aspect has to be looked into by the RP. Coming to section 110, which deals with the rights of secured creditors. Again, this is similar to section 52, which deals specifically with secured creditors. So what are the rights here? We have to see. Subsection 1 says secured creditors shall be entitled to participate and vote in the meeting of the creditors. A secured creditor participating in the meeting of the creditors and voting in relation to the repayment plan shall forfeit his right to enforce the security during the period of the repayment plan in accordance with the terms of the repayment plan. So here, somewhat similar to what we have seen previously under 52, the secured creditor is given an option. You either enforce your right or you abstain from voting here. So here, if he sits in the meeting of the creditors and votes, he loses his right to enforce the security in through any other applicable law. Subsection 3 says, where a secured creditor does not forfeit his right, he shall submit an affidavit saying the following. This affidavit will be submitted to the RP, saying 1. Right to vote exercised by the secured creditor is only in respect of unsecured part, if there is any, and estimated value of unsecured part of the debt. So this is just to clarify that now I am sitting in the meeting only for one reason, which is whatever unsecured debt is there, I am voting in respect of that, not with respect to the secured part of it, because that I refuse to forfeit. I will enforce it in a manner I deem fit. Subsection 4 says, in case the secured creditor participates in the voting on the repayment plan by submitting an affidavit, the secured and unsecured parts of the debt shall be treated as separate debts. So that again, this is just a corollary of what the subsection 3 says, because that's a logical inference of subsection 3. Subsection 5 says, the concurrence of the secured creditor shall be obtained if he does not participate in the voting on repayment plan, but provision of repayment plan affects his right to enforce security, right? So that again is a matter of a later point of view, where if the repayment plan is somewhat affecting his security, let's say the security here is a land, the repayment plan deals with the lands in one way or the other, right? Now, even if this secured creditor has forfeited his right, because the lands are mentioned in the plan and because there is an effect on these lands, he will get a right to, to be consulted by the RP before going ahead with the proceedings. Explanation clarifies what the period of repayment plan means. It basically is the period from date of order passed under section 114 till the date on which the notice is given by the RP under 117 or report submitted by the RP under 118 as the case, which we shall see subsequently. Section 111 deals with approval of the repayment plan by the creditors. Repayment plan or any modification to the same shall be approved by a majority of more than 3/4 in value of the creditors present in person or by proxy and voting on the resolution in a meeting of the creditors. So it's 3/4 present and voting, right? 75% as opposed to the 66 that we have seen in the usual CIRP as well as PPIRP. Section 112 is report of meeting of creditors on repayment plan. The RP shall prepare a report of the meeting of creditors on the repayment plan. Again, keep in mind this meeting itself is subject to discretion. So if it is conducted, then the RP will have to prepare a report. What shall the report contain? It shall contain the following. A. Whether the plan was approved or rejected, and or approved, list of modifications if there were any modifications made. B. Resolutions which were proposed at the meeting and the decision on the resolutions. C. List of creditors who were present or represented, voting records of each creditor, etc. And D. Such other information which the RP thinks appropriate, the NCLT will have to know. Section 113 deals with notice of decisions taken at meeting of creditors. It says the RP shall provide a copy of the report of the meeting of creditors prepared under section 99 to the following people. A. The debtor. B. The creditors including those who are not present in the meeting. And C. The adjudicating authority. So this is to avoid any further claims, because once you are in the list of creditors, you are entitled to know what all is going in the resolution process. However, if you have not attended the meeting, it does not mean you will be kept in the dark. You will receive information, right, to ensure that there is no further complexities. Now, subsection 114 says order of adjudicating authority on the repayment plan. So this is the next step in the process. The adjudicating authority shall by an order approve or reject the repayment plan on the basis of the report of the meeting of the creditor submitted by the RP under 112. So the decision of the adjudicating authority here is based on the RP's report, which itself is based on the meeting of the creditors. So here it's quite simple. The creditors will sit, the creditors will discuss the repayment plan and then take a call. That is communicated to the RP. The RP will then go through everything and then make a report. That report will then go to the adjudicating authority. So it's kind of a 3-step verification here, and ultimately the call will be taken by the adjudicating authority based on whatever record, comprehensive record that it has seen. Now here again, the meeting of the creditors is something which is summoned at the request of the RP and the discretion of the adjudicating authority. What if that meeting was never summoned, right? The proviso says, where a meeting of creditors is not summoned, the adjudicating authority shall pass an order on the basis of the report prepared by the RP under section 106. So the previous report, right? So basis that report, if there is no meeting of creditors, whatever has been discussed by the RP under section 106's report, that will become the basis for the adjudicating authority to either approve or reject the plan. Subsection 2 says the order of the adjudicating authority approving the plan may also provide for directions for implementing the repayment plan. So here if you look at it, there is one crucial distinction, right? So far whatever is seen in respect of the resolution plan or the base resolution plan, etc., is that the plan itself should include aspects or include relevant grounds or relevant things to show how it will be implemented, right? Here, however, it is now left with the adjudicating authority. The onus, or rather the discretion is now on the adjudicating authority to impose directions for implementing the repayment plan. Subsection 3 says where the adjudicating authority is of the opinion that the plan requires modification, it may direct the RP to reconvene a meeting of the creditors for reconsidering the repayment plan. So here again, instead of rejecting straight away, the RP is again called and the creditors are given one more chance to further decide and reconsider the repayment plan. This is based on the adjudicating authority's opinion. So this again you can see kind of flies against the commercial wisdom aspect that we have seen so far in CIRP or PPIRP, etc. So here again there is a slight departure in respect of the overall procedure of the code, but with good reason, right? Again, what needs to be kept in mind here is that this entire chapter deals with a situation which is more peculiar in nature, right? The stakes here, the nature of the stakes, even if not the monetary value, the nature of the stakes here are quite different. And for these reasons, you cannot have the same kind of structure or system which is in place for CIR, for corporate entities. Therefore, these differences are somewhat required and are necessary. Now, what happens when the adjudicating authority passes an order? When the AA has approved the plan under 114, such repayment plan shall A. take effect as if proposed by the debtor in the meeting, and B. be binding on the creditors mentioned in the repayment plan and the debtor. So it's applied on these stakeholders, because these are our only stakeholders in this chapter. As you might have noticed, it's only the creditors and the debtors. Subsection 2 says where the adjudicating authority rejects the plan, the debtor and creditor shall be entitled to file an application for bankruptcy under chapter 4. Subsection 3 says a copy of the order passed by the adjudicating authority shall be provided for the board for the purposes of recording an entry in the register referred to under section 196. Now comes the implementation and supervision of the repayment plan, which again is something unique to these processes. The RP appointed under 97 and 98 shall supervise the implementation of the repayment plan. Right, so here the RP's role does not come to an end, it will extend. Right, even after approval of the plan, the RP will now have a supervisory role to see the implementation of the repayment plan, because here if the RP is not there, there is nobody else. There is no resolution applicant to go ahead with the implementation of the plan. There is no SRA, there is no PRA, there is nobody else but the RP, creditor, debtor. So the RP will have that supervisory role naturally. Subsection 2 says the RP may apply to the adjudicating authority for directions if necessary. So if directions have not already been provided by the adjudicating authority in its admitting order, in its allowing order, then the RP can separately apply. The adjudicating authority may issue such directions as sought for. Now coming to 117 is the completion of the repayment plan. So here it says the RP shall within 14 days of the completion of the repayment plan forward to the persons who are bound by the repayment plan the following documents. Namely, a notice that the repayment plan has been fully implemented, which is completion, right? So where the restructuring is proposed and all those required changes have been carried out, then notice first will have to be issued, and B, copy of the report of the RP summarizing all receipts and payments made in pursuance to the repayment plan, and extent of the implementation of such plan is compared with the repayment plan approved by the meeting of the creditors. So here if there are any differences, the RP will give a comprehensive data, will collect all the data and provide it along with the notice. Subsection 2 says the RP may apply to the adjudicating authority to extend the time mentioned in 1 for such period not exceeding 7 days. So here again you can see the timelines are quite cut short and are strict. Now section 118 envisages a peculiar circumstance where the repayment plan comes to an end prematurely. What is a premature end is clarified under subsection 1, which says a repayment plan shall be deemed to have come to an end prematurely if it is not been fully implemented in respect of all persons bound by it, within the period as mentioned in the repayment plan. So three things. First, the plan has not been fully implemented. Second, it has not been fully implemented in respect of all the persons. And third, this implementation or rather lack of implementation and has not been done within the time period mentioned in the repayment plan. Subsection 2 says, when this premature end happens, the RP shall submit a report to the adjudicating authority. Right. So here you can see that the role of the RP with respect to the adjudicating authority is only to keep the adjudicating authority apprised of what is happening. And the role of the adjudicating authority, whatever decision it is taking, is based solely on the report of the RP, which in turn might have some consonance or might have some consultation with the creditors, but still it is based the report of the RP. Now, what will the report of the RP contain when the plan is prematurely come to an end? A. Receipts and payments made. B. Reasons for premature end. And C. Details of creditors whose claims have fully not been satisfied. Now, basis this report, the adjudicating authority will pass an order, and here the debtor or creditor. Now, the order will be passed by the adjudicating authority. What will the order say? It will basically say that the debtor or creditor whose claims under repayment plan have not been fully satisfied shall be entitled to apply for bankruptcy under Chapter 4. So, that is what the order of the adjudicating authority will be passed, that to basis the report of the RP. Adjudicating authority shall forward to the persons bound by the repayment plan the RP's report and its order. And a copy of all of this will also be given to the IBBI for the registry of register as provided under section 196. Now coming to section 119, which deals with discharge order. Subsection 1 says, on the basis of the repayment plan, the RP shall apply to the adjudicating authority for a discharge order in relation to the debts mentioned in the repayment plan. Now here this is one additional order. Any order which first admits the application or an order which allows the repayment plan, etc. are different. Here this third step is mandatorily required, which is the passing of the discharge order. The repayment plan may provide for an early discharge or discharge on complete implementation of the repayment plan, right? So that again is something which is left to the debtor while preparing the repayment plan, and of course subject to the subsequent scrutiny of the creditors. Discharge order shall be forwarded to the board again for 196, and the discharge order shall not discharge any other person from any liability in respect of his debt. So that is quite simple in nature, right? Section 120 says, standard of conduct. The RP shall perform his function and duties in compliance with the code of conduct provided under section 208. So here again, instead of the provisions spelling out the functions and duties of the RP, it makes a reference to section 208, which we shall see subsequently along with section 196. Now, before proceeding with bankruptcy order for individuals and partnership firms, a very crucial aspect which has to be underscored here is that chapter 4 in itself is vast, right? There is a separate procedure itself for bankruptcy. So instead of going through the whole procedure, it will suffice if we go through section 128, which deals with effect of bankruptcy order. Now keep in mind, bankruptcy will happen when the repayment plan is unsuccessful, or the grounds that we've seen previously, right? When the debtor has failed to in effect restructure his debts to the satisfaction of his creditors, then in that case he will be declared a bankrupt. Now what is the effect of a bankruptcy order which is passed under section 126 by the adjudicating authority? It says, on the passing of bankruptcy order under 126, A. Estate of the bankrupt shall vest in the bankruptcy trustee as provided under section 154. The estate of the bankrupt shall be divided among his creditors. And C. Subject to provisions of section 2, a creditor of the bankrupt indebted in respect of any debt claim shall not initiate any legal action against property or commence any suit. So here again you can see that even in respect of bankruptcy there is somewhat a provision which is similar to moratorium, right? So this, as you can see, is a very separate procedure in itself, which is vast and lengthy and not that relevant for our purposes, because here right now we are dealing with PG solely, right? So these provisions, there is a dearth of jurisprudence in respect of these provisions, and the process in itself is quite technical and not very relevant to us at this stage. But all we need to understand is If the resolution process fails, then bankruptcy is the next stage, and the bankruptcy essentially is all the assets of the creditors, all the assets of the debtor will be divided amongst his creditors in such manner as is provided and as per adherence to the process which has been provided under chapter 4. Now one other provision which is somewhat relevant to us because we've seen it recur here and there is the section 196, which deals with the register. The board shall, subject to general direction, register insolvency professional agencies, professionals and IUs, and renew, withdraw, suspend or cancel such registrations. So here, collect and maintain records relating to insolvency and bankruptcy cases and disseminate information relating to such cases. So this again is for one main purpose, right? Previously in India, whatever insolvency and bankruptcy legislations are there, or any legislation that purported to be an insolvency legislation, has not been that beneficial or has not been that successful. The IBC was brought about in 2016, right, which is quite some time after our independence, and it took a long time for us to come to the standpoint of the IBC. Therefore, it is essential to see that the court's functioning is not painted to be much rosier than what it is, right? So for that reason, you need data. You need data on how long is it taking for a proceedings to complete, or how is the general manner of conduct of the proceedings, how is it beneficial to the creditors or to the debtors or to the stakeholders, how are they being impacted. All of this is much required. Therefore, this duty of the IBBI is stretched upon even in the chapter that we've just seen. So with this, we do come to an end of this topic. However, there are some additional reading materials which we could not go into for the purposes of this session, and if we do start going into that, it will require us a separate session, but I'll be displaying those documents here so that you can take a note of those. Now these two documents are the genesis. They explain the entire origin, reason, grounds, etc. for why this system for insolvency resolution process and why subsequently the PG resolution process, why was this brought about, right? So this is the report of the working group on individual insolvency. In parenthesis, you can see the clarification, right, regarding strategy and approach for implementation of the provisions of the IBC to deal with the insolvency of guarantors to corporate debtors and individuals having business. So this was in August 2017. Subsequently, another report was passed in October 2018, was published, which deals with strategy and approach for implementation of IBC in respect of personal guarantors to corporate debtors, partnership firms and proprietorship firms and other individuals. So here, these two documents, if you go through in a comprehensive manner, you will have a very, very, very holistic understanding of the personal guarantee and individual resolution process which has been envisaged under the code. And the reports are in fact so comprehensive, you will also see how and why they are much more better than what used to exist in India prior to the IBC, including these chapters that we have discussed. So with this, we come to an end of the session. I hope this chapter has been clearly understood by each and every one of you, and please do go through these reports to get a better understanding of the same. Thank you very much.